a lot of cases are tossed in conference, but this is so unusual,
Unique.
different,
Yep.
the story behind it, that I'll tell you, once it makes out of conference, unless it's completely adjudicated, maybe it's just supposed to be under the radar and get all
Right.
done, and people will go, "Wow, what's happening?" It's good.
Right. Well, and that's kind of the weirdest thing about it is I hope, because um for what we've lived through, I go all the way back to 20, when Obama took office, going back to that level of, the corruption that's just gone unnoticed. I guess wouldn't say unnoticed, unprosecuted. It's a second tier law system that, that they are under. They can commit anything and nothing can happen to them. And that mindset is just so universal across the nation in terms of people like me and the people that are dads, husbands that have a job that just kind of go out and do their thing. They've taken advantage of our virtue, and they've taken advantage of our kindness and our goodness and things that we've kind of held insulated, that I think that we've, in that awakening process where we're at now. But at the same time, I look at it and I got to be honest with you, Lloyd, I want to believe your case so badly. I want to believe the fact that everything that I've heard and know is going to happen. Because this isn't a case of, well, there was fraud in the election, but this is such a new revelation of what's happened and what you guys have done. And that has nothing to do with that. This is all procedural and about the oath. So if you could just kind of talk about that a little bit.
Yeah, absolutely. The defendants, there are 388 of them. 387 of them currently hold federal offices. And this literally gives the power to the Supreme Court to remove from office the sitting president, vice president, and 385 members of Congress. For what they did was they participated in a massive national security breach by not responding positively to the request from 100 members of Congress to launch a 10-day investigation. And as you said, it has nothing to do with the outcome or who would be president and who would fill those seats, but it has everything to do with, they have taken an oath to the Constitution, a binding oath. Now, Article 6 of the Constitution is very clear. It states they shall be bound by oath to this Constitution. And the Congress took an oath to defend the Constitution against all enemies, foreign and domestic. And when you have 100 members of Congress presenting a mountain of evidence and testifying that there needs to be an investigation, and they don't investigate, and there were some other rules that were violated too. They didn't. There were some serious problems with them just moving forward,
Right.
and they ignore that and vote against it. Not only that, they hold up and wave the Constitution. Remember, you probably saw some of them waving. You think people you'd never dream of holding up the Constitution and talking about how wonderful it is. And here they are saying that they have an oath to the Constitution to ram this through without an investigation. And what they should have said is, we have a constitutional duty, a bound oath that requires us to take a pause here and investigate to make sure that the electoral votes that we're about to certify are real, that they're legitimate, that they aren't fraught with compromise and fraud, so that we can actually do our duty. But instead, they just did the opposite. So it's not a severe relief to ask that they all be removed from office. Not only be removed, but barred from holding public office the rest of their lives, to prevent another security breach. So this case also, not only would we have the power to remove them and bar them from holding office ever again, but it would also strip the immunity. There are statutes, there are federal and there are state statutes that give these representatives unconstitutional immunity. In California, there's a state statute that's very clear, and it excludes, the wording is, you can be charged with crimes of perjury, but the exclusionary part of it is unless you're a politician, and it has to do with the oath of office. That's about as obvious a violation of the Constitution right in your face that there could be. So So this could be a tremendous and easy kind of one fell swoop to change not just the positions that would be filled with these vacancies, but to also eliminate a lot of people that have been running for office for the wrong reasons. Because now the oath is going to be binding. Now you need to have some kind of an understanding of the Constitution, or you can be held for perjury.
Right,
If you
right.
don't read the Constitution. So anyway, I hope that answered your question.
Yeah, it did. And but it also, that same oath that you were talking about also, doesn't that also apply to the Solicitor General and to all the justices as well? So they, by not taking up this case, or by not, even looking at it for it to go into conference, wouldn't they be then slitting their own throat, so to speak?
Absolutely. They would actually be violating their own oath of office as well. And that's why I believe the United States Solicitor General, when she came on board, she immediately signed a waiver and filed a waiver waiving their right to oppose the petition, because opposing it would be a violation of their oath. And so far, the Solicitor General has kept her oath. So far, the justices have kept their oath. Now, the United States Supreme Court justices have taken 2 constitutional oaths. They take one that is called the judicial oath, which includes supporting and defending the Constitution. But they also take an additional oath that's mostly the Constitution, where they swore to protect the Constitution against domestic enemies, foreign enemies, and to take it without any kind of mental reservation, so on and so forth. So they have been acting in good faith too. They have been upholding their oath by reaching out to us after we sent them the Rule 11. They didn't have to accept our petition under Rule 11, bypassing the 10th Circuit. They could have said, go back to the 10th Circuit. They haven't made a decision. You can't come here yet. But for them to accept our Rule 11, call us on the phone, they are keeping their oath. To this point, they are completely upstanding and keeping their oath that they've sworn to uphold and defend the Constitution and protect it from all enemies, and domestic and foreign. So right now they're 100% so far, and we hope that they keep this up.
Yeah, and I think they've set precedents with the Roe versus Wade decision as well, almost in a boldness that kind of a wink and a nod to everybody that is in kind of in that sense of, our justice system's corrupt. They're not going to do anything with this. This is a nothing burger. All that kind of stuff. But I want to kind of also, which is in the same light of this, what other ramifications that you have? The 368 members of Congress that are on there. We live in Illinois, and we're in the belly of the beast. I want my governor to be on that. So is there a way that I mean, is it just the Congress, or is there other people that can be added to this? Because he was just as much involved in this, in the 2020 election debacle, as anybody else, but yet he wasn't up there in that suit. Is there anything in the wording that can be them added to it?
Oh, absolutely. And that's a great question. There are actually 385 members of Congress. Okay. There's also John Doe's 1 through 100. It's kind of a normal thing that lawyers include when they're filing a civil complaint or a lawsuit. And that is, the Supreme Court has the full power to add any other defendants that they feel like should be added to that. And I'm even thinking there could be some governors. It could be the directors of the Federal Communications Commission, because the Federal Communications Commission directors have sworn to uphold the Constitution too. So any allowance, anytime they allow any of the stations that they supervise, that they are directors over, anytime they let them broadcast anything that would be demeaning or compromising or slandering or defaming the Constitution of the United States, they have an obligation to stop it and to not allow that to happen again. So they could be added to this as defendants. And also, I just wanted to mention that the media is a big part of this, a big part of the problem, as you know.
Yeah.
And so they could actually, the government, through the Supreme Court and through the Circuit Court, through the Marshal Service, and through coordinated efforts, there could be special military broadcast teams, suit and tie kinds of people that go into the broadcast houses and take over, almost like a bankruptcy receivership, where it's taken over while the licenses are reevaluated, maybe replaced with, new owners, and so that we could see a whole new faces, so no one would recognize it as being left or right. But then we would start seeing the news broadcast in real time, the real truth, to help people understand that this is not a crisis, that things are moving forward in a swift and calm way, and we're going to get rid of the lies, we're going to get rid of the propaganda, we're going to get rid of all the horrible fraud that's been happening through the media up to this point, and through our representatives.
Yeah. So a devil's advocate would be asking you this is, so what if this gets tied up in appeals, and, so what procedural?
You can't appeal.
Well, wasn't there something on Thanksgiving, the day after Thanksgiving, there was what was that process? There was there was
a deadline. There was a deadline for the U.S. attorneys to file an opposition. They were given over 30 days. Now, that was the 23rd of November. The day was up. So hours before the deadline was up, the U.S. attorneys were relieved of their duties. I don't know exactly how that happened, but they were relieved of their duties, and the United States Solicitor General came on board as the attorney of record, representing the 388 defendants. And so, and she also, instead of asking for an extension, or instead of opposing the petition, which she could have done, she filed a waiver waiving their right to oppose it, which allows it to smoothly head right in to a docket date for conference, which is exactly what happened. January 6th is the conference date.
Well, I mean, I think that also is a significant date, for them to put it on January 6th. I mean, and also the fact that the clerk was so, I mean, you would call and they would answer right away, and they were just so.
Yeah.
Or when you were doing that process of the Rule 11, and then the 10th Circuit went ahead and pushed it through, and then now you're sitting with. So how do we amend this? And they told you exactly how to amend it and put it through this way and do that way. And they almost held your hand through that process, as opposed to. So that just gives me hope, saying, okay, they want this. They want you to succeed with this.
Yeah, they were great. And they asked for additional information that's not required. They asked us to put in the motion to dismiss. We also put in our opposition to the motion to dismiss, which was not required. And what this does is this gives them more leverage. So if there's any kind of a complaint about, oh, well, we didn't file an opposition, we filed a waiver, maybe we should have opposed it. It's like, hey, Brunson's put your motion to dismiss in it, so you're covered. I'm just speculating there. It wasn't necessary.
Right.
So for them to coach us along those lines, and then for them to ask how soon we could get it. I mean, the first time that we submitted it to them under Rule 11, they called and said that they would accept it. And I just want to mention that the clerk of the court is not a justice clerk. There are 4 justice clerks for each of the justices. The clerk of the whole court is much different situation. For 11 years, he was the attorney representing the United States Supreme Court. He is the gatekeeper, and now he's the clerk of the court, Scott Sessions Harris. And his job is to research and prepare and to help align everything properly for the justices, to help them gain more materials should they need more materials and more information. And so the case analyst assigned to us, it was unbelievable. It's like whenever we call it, it's immediate. It's almost like she has this one responsibility to work with us, so there's no hesitation or delay in our communications back and forth. And then for them to request it as soon as possible, and we say, well, it's going to be a couple of weeks. They go, please send it to us sooner. Would like to have it sooner. And then we got it to them sooner. We sent it on a Thursday. They got it on a Friday, and Monday they docketed it. So it's pretty swift. And then they sent my brother asking him if he would send the U.S. attorneys the form to file a waiver. And then they finally did that. The U.S. solicitor finally did that at the day that it was due. So there are a lot of elements to this that give us a lot of hope and tell us justices on top of it.
I totally think just in what we've done at Freedom Square, everything we say that has happened, every decision that's been made through our humility in our submission to our goal, our mission. We have called everything that we've done divine appointments, and I think divine appointments have happened along the way. We've acknowledged them as divine appointments, and I think then we anticipate another one coming after we've acknowledged that, not taking us the credit for it, but giving God all the glory and him the credit, and him the in terms of a testimony. When somebody says, I can't believe this happened, say, this is all God. I think I love the fact how when, I mean, this is kind of going a little deep in the weeds, but I think it truly is a God thing with the trumpets in Scripture, and what you guys formerly were as brothers. You were the trumpet. You guys were on Carson when you were little back in 20 years ago. But I just think all the symbolisms and all the things that God is basically saying, I got this, and He's using people, laymen that are just out there doing that, and what He's turned this into. I am so encouraged. I am so excited about this as well, and I know you guys are too. Especially, this just didn't happen over a whim. I mean, you've invested 2.5 years of your whole life and finances and all that stuff. So, what are some of the ways that our viewers and our members, subscribers can do to help you? I know we've got. Can you explain a little bit about the 2-letter campaign? I'll also have a link in there to do that, so they can download, sign, and send. If you can just explain a little bit about what that is, that campaign.
Yeah, you can go to 7discoveries.com, and there's a link there. I need to look at it again, but if you look around, you'll find a link, the history of the case, or whatever. It'll take you to show you a format for a letter writing. If you'd like to write a letter to the Supreme Court and send us a copy, so we have like a receipt that you sent a letter. You can donate $1 for a download. I know that may not sound like much, but it's a big deal to go and do a $1 download. You can get the petition, the exact copy of what the Supreme Court justices will be using with their stamp. We downloaded their cover so that we could print some with their cover with their stamps on it, for a $30 gift. And for a $1,000 gift, you can actually get an exact what they have, but signatures of the Brunson brothers. So we all signed some of those. So if you have deep enough pockets to do a $1,000 gift, we can get that one to you pretty quickly too. So, and then the pocket constitution is much more than that. There's a little picture of it behind me. It has my 7 discoveries that I've contributed the constitutional part of this petition. And so you can get something that fits in your pocket. It has Q&A, and it has discoveries that highlights clauses that have been overlooked for over 200 years. That shows you that's why we're having a problem, is because we've overlooked and not given attention and recognized the power within these clauses of the Constitution that have been overlooked. So that's available too at the website. So yeah, that'd be great. Go to 7discoveries.com, send a letter to the Supreme Court. And I believe the Supreme Court, every letter that comes to them, I think they file it. And so I'm hoping someday there'll be a huge wall with everyone's letter.
Yeah, wouldn't that be great? I think I could get visual. Yeah, a wall. Just you walk in and it's just all these letters. That would just be so touching.
That'd be great. And also, if they decide that they're not going to let it move forward, which you can't imagine that happening, we have a motion for reconsideration that we can do, and with enough support from letter writing and people in the United States, as they become aware of this, could actually overturn their decision not to hear it. Plus, we have another full complaint that's still alive, has not been dismissed. It was filed. And then the U.S. Marshals were ordered to serve it. Nancy Pelosi and a bunch of others were served. Then the court unfiled it and blocked me. So we took them to the 10th Circuit, and that didn't work. We took them to state court, took 2 federal courts to state court. And after all that, they unblocked it and filed it and ordered the clerk of the court to issue 388 summonses. So that's still alive as well. So we're not ready to quit on this, no matter what happens.
Well, that's great. I thank you for everything you guys have done in this. We're right at the 5-yard line. Boy, Brunson, again, I can't thank you enough for all you've done. I'm so looking forward to the next, what, 8 days? What are we at? 7 days?
We're getting close.
We're getting close. We're getting very close. And actually, to that point, they could adjudicate this anytime. It's not, I mean, it's on the docket, right, for January 6th, but they have the power just to come out tomorrow morning and say, you know, we could see that, correct?
Right. That's absolutely correct.
Yeah. So that's exciting. So but it can't go past January 6th, right? It has to be, we'll know something by January 6th.
They could extend it. They could do
Okay.
anything. They have the full power. You can't appeal a decision made by the Supreme Court.
Well, hopefully the trumpets will sound prior to that, is what we're hoping. So,
Great.
but all right. Well, hey, thank you so much for your time, and we will get this out. We'll send you the links to this interview as well. I know you're so busy, but you're an honored. It's an honor to be on with you, and we'll keep in touch as this thing happens and unfolds.
Right.
So in
Right.
real time.
Thank you.
All right. Thanks a lot, Loy. I appreciate it. Talk to you later.